Hello everyone, welcome to Ab Initio. As we all know that our prelims examination is going to be held on 21st May 2023, and for which we have decided to cover few of important MCQ questions of previous year paper. In this video we will be covering 2018's CrPC important questions for your preparation, and let us know in the comment box which portion you want us to cover, so that it will be helpful for your preparation. So without any delay, let us start our today's session of 2018 previous year question regarding the CrPC. Thank you. So our first question is regarding the summons. So here it goes. The procedure for serving the summons is provided under dash of the Code of Criminal Procedure 1973. So the options are section 59, section 60, section 61 and section 62. So the correct answer is section 62. So let's have a look on the bare act. So the chapter 6 of section 62 talks about summons have served. Section 61 talks about forms of summon, which is given under schedule 2 form number 1. These are the contents of summons, but section 62 of CrPC talks about summons have served. So it is given that when it will be served by a private individual or by a police officer, you can refer to section 62 to know more about the serving of summon. So next is section question number 2, that is X, a married man, had illicit relation with Y and a child was born from that relationship. Later X deserted Y, filed an application for maintenance to her and her child from X. Decide Y. Option number 1 is Y and her child are entitled to maintenance from X. Option number B, Y and her child are not entitled to maintenance. Option number C, Y is not entitled but her child is entitled to maintenance from X. And lastly, none of this. So we all know that provisions relating to maintenance are given under chapter 9 of CrPC. To be very particular, it is given under section 125 CrPC. So let's have a look on section 125. So chapter 9 and section 125 talks about order for maintenance of wives, children and parents. If any person having sufficient means neglects or refuses to maintain his wife, unable to maintain herself, first the person seeking maintenance under 125 has to be the wife of such person. Nextly, option B, his legitimate or illegitimate minor child. So our answer regarding this question is provided under section 125 subsection 1 B of CrPC. So the correct option answer would be option C. Y is not entitled but her child is entitled to maintenance from X. But there are various judgments where live-in partners have been given proper legal recognition to claim maintenance under 125. Chanmunia case, if you have heard of it, which allows the live-in partners to claim maintenance under section 125. But here the correct answer would be option C, by virtue of section 125 subsection 1 and clause B. Now question number 43 is regarding an order under section 144 of Code of Criminal Procedure. Option A may be passed ex parte, cannot be passed ex parte, can be passed only after an inquiry, and none of these. So from these the correct answer would be lies in section 144. Let's have a look on section 144. See, section 144 CrPC, urgent cases of nuisance or apprehended danger. 144 power to issue order in urgent cases of nuisance or apprehended danger. So here our required provision would be subsection 2. Subsection 2 of section 144 talks about an order under this section may, in case of emergency or in cases where the circumstances do not admit of the serving in due time of a notice upon the person against whom the order is directed, be passed ex parte. So in case of emergency there can be an ex parte order without serving the notice upon the person against whom the order is sought. So the correct answer would be option A. The question number 43, the correct answer would be option A. Nextly, the Supreme Court upheld the constitutional validity of section 151 of Code of Criminal Procedure 1973 in first of all, we all know that under section 41 the police officer can arrest a person without warrant. Various grounds have been propounded under section 41 which empowers a police officer to arrest a person without warrant. But apart from that, while the police officer, while exercising the power to prevent any offence under section 151, he also can arrest the person, which various times seek that whether the such provision is constitutional or not, or whether it is against the spirit of article 21 or not. So it was asked that in which judgment it was held that such provision is not unconstitutional. So for this the correct answer would be Ahmad Nur Ahmad versus State, option D. So let's have a look on the given citation. So this case came before the Honorable Supreme Court to check the validity of section 151 CrPC, which states, and I quote, that the petitioner herein filed a petition before the High Court of Gujarat at Ahmedabad under article 226 of Constitution of India and section 482 of CrPC. In this petition, the petitioner prayed for quashing of the criminal proceeding initiated against him on the complaints of respondent 5, 6 and 7. He also prayed in the said petition for a declaration that section 151 of the Code of Criminal Procedure is unconstitutional and ultra vires. So while deciding the issue, Honorable Supreme Court held that, here you can see that section 151 is not unconstitutional, rather it is constitutional in nature. It is not against the spirit of article 21 of Indian Constitution. Here you can see that we therefore find no substance in the contention that section 151 of the Code of Criminal Procedure is unconstitutional and anti-varies the constitutional provisions. So here it is clear that the option D is the correct answer, where the constitutional validity of section 151 of CrPC is upheld. Now moving towards our next question. Question number 45 is regarding which of the following powers is not available to a police officer who receives an order from the magistrate to investigate a non-cognizable offence. First of all, we all know that section 154 talks about information as to cognizable offences or cognizable cases, but under 155 CrPC it talks about information as to non-cognizable cases. So let's have a look on section 155. Here under section 155, information as to non-cognizable cases and investigation of such cases. You can refer to my previous video where I had clarified what is the difference between an offence and a case. Here under section 155, subsection 3 talks about any police officer receiving such order may exercise the same powers in respect of the investigation except the power to arrest without warrant as an officer in charge of a police station may exercise in a cognizable case. So by virtue of section 155 subsection 3 of CrPC, the correct answer would be option C, power to arrest, where it suggests that the police officer in charge of a police station may exercise all the powers except the power to arrest without warrant. Next is section 40, question number 46. Which of the following sections of the CrPC deals with the examination of witness by police? So it is a straight question. The correct answer would be option C, section 161, where the police officer interrogates or put questions or examines the witnesses including the accused under section 161. To be very particular, section 161 gives the police officer to gives power to the police officer to examine any person acquainted with the facts and circumstances of the case. Nextly, question number 47. Which of the following sections of the CrPC deals with medical examination of victim of rape? So it is again a direct question. The correct answer would be 164A, option B, and it falls in the chapter 12 of CrPC. 164A. So let me tell you the correct year of amendment of section 164A is 2005. It was inserted by Act of 25/2005 with effect from 23 June 2006. It came by way of an amendment in the year 2005, and it was indeed a recent amendment where medical examination of the victim of rape is to be conducted. Similarly, section 53A talks about the medical examination of the accused and many more. Question number 48 talks about who among the following may file an application for plea bargaining. So here the plea bargaining application can be filed by the accused. So we all know that provisions relating to plea bargaining has been dealt under 265 A to L. So let's have a look what does it say regarding the plea bargaining. Here first is application of the chapter. So it sets an yardstick to determine which cases can come under the purview of plea bargaining. Then section 265 B talks about application for plea bargaining. Firstly, subsection 1 talks about a person accused of an offence may file an application for plea bargaining. So, from the very inception, it is made clear that any person or a person accused of an offence, that means the accused can file the application for plea bargaining. So, the correct answer would be subsection option A, the accused, by virtue of 265 B subsection 1, the accused can file the application. Question number 49 talks about which of the following section of the code of CrPC deals with set-off. It is again a direct question. The correct answer would be option A, section 428. Talks about the set-off. In which of the following cases, those who are not aware about the concept of set-off, it is different from the set-off given under CPC. Under CPC, set-off is a whole different concept, whole new different concept, but under CrPC, it talks about the calculation, the period during which the accused had spent as an under trial prisoner. That period is to be deducted from the punishment given in the judgment. Suppose the accused remained as an under trial prisoner of 2 years, and later on the court held him as a convict and awarded a sentence of 5 years. Then the 2 years which was served as an under trial prisoner will be deducted from the substantial punishment of 5 years. Now the accused has to undergo as an imprisonment of 3 years. So, this is the concept of set-off which is given under 428 of CrPC, which is again to be very precise, 428 talks about period of detention undergone by the accused to be set off against the sentence of imprisonment. So, popularly or famously it is called as set-off, but we can remember it as the period spent as an under trial prisoner has to be excluded from the substantial punishment given in the judgment. Now, question 50 talks about in which of the following cases the Supreme Court held that mere rejection of anticipatory bail applications cannot be a ground for arrest. So, the correct answer would be option A, MC Abraham versus State. It is again held that mere rejection of anticipatory bail cannot be a ground for arrest. It is again a landmark judgment. We all need to remember this to put it in our mains answer writing question, that MC Abraham versus State, it was held that mere rejection of anticipatory bail application cannot be a ground for arrest. So, with this, let us conclude our today's session. We will again meet with a new previous year question bank discussion. Till then, have a very good day. Bye bye.